that the issue of mandate regarding JP and the acceptable use of the word mandate, but that was mentioned to you on the 23rd of April in the telephone call to alert you that the Chief Justice had given him a mandate which would go back to the Chief Justice. And that was because he was chairing a local organized company in Cape Town regarding a forthcoming Commonwealth conference. And that's how you came up with that term. Okay? The second one is this.
Do I have to comment, Mr. President?
You are entitled to.
It was a local organizing committee that this was mentioned to you about. Okay? Secondly, this.
Mr. QC, might I comment before I forget? If you mention all the points, is it fine if I comment to the first one?
Well, it's a matter for you, or whether, for example, you want to deal with the matter through your own advocate in due course. But I want to deal with this as swiftly as possible, if you agree.
Thank you, QC. Mr. President and members of the tribunal, I request that I comment to this proposition, depending on what will be put to me hereafter. But might I just briefly say my piece on this proposition? My answer is two-pronged. First, QC, I agree that the JP mentioned the issue of privilege when he phoned to arrange a meeting with me. I beg your pardon?
Sorry to interrupt
I beg your pardon. I beg your pardon.
But I made a point about mandate.
I beg your pardon.
I'll be coming to privilege in a moment.
I beg your pardon. Yes, of course, I made a mistake. He mentioned the question of mandate when he called me, arranging to meet me. I agree with that. The second point that I would like to raise in relation to that is the narrative that I see from JP's papers that I actually asked him during our meeting to what he was doing in the court. And I find it strange that with this proposition, and also given what is in the papers, he could ask me that question because he knew that he was coming to the court. I knew he was coming to the court. And so how could I ask him what he was doing in the court?
The next point that I put to you is this: that he did not speak to you on the telephone about the issue of privilege.
Thank you, QC. As I said earlier, I am not a Zulu-speaking person, but I do understand. JP, at the end of that telephonic discussion, said something to the effect so that we can look at this thing or issue of privilege. Something like, privilege, something like that. So he did.
During that telephone call, nothing was said to you about the roles of other judges involved in creating judgment in those cases. There was no mention of that at all, was there?
Would you please repeat the question or the proposition, QC?
Did you become unaware of the roles judges in the Constitutional Court was concerned, that he knew about that? Did he say anything to you to that effect? That he knew the roles being played by judges in that court about those 4 outstanding decisions.
During the telephonic discussion?
Yes, please.
Not at all, sir.
Did he, for example, during that telephone call or at any stage, mention to you that he knew you were the one dealing with privilege?
He did not say that to me.
Thank you.
But I might add that I was surprised that he did talk about the very issue that even when you look at this record, he says was of importance, and he had strong views about it, and clearly he had discussed it with Judge Shafter. And I was wondering, how then did he know that I wrote about privilege? I was wondering.
Are you suggesting that during that telephone call, he suggested that he had knowledge of what you were working on?
Not in the telephone call, he didn't.
Thank you. At any stage, are you suggesting that he tried to influence you about anything?
In my view, and given the fact, as I said earlier, that the matter had been heard by the justices of the Constitutional Court, judgment was pending, I had been allocated to write on this critical issue, which he also says is of importance, and I had written on this issue and circulated a note to all my colleagues for their comment when he arrived on the 25th of April to my chambers. And also given the fact that the court sits in bank, by the way, all matters that come before the court are considered by the minimum in terms of the Constitution of 8 judges. But our practice is that we try to sit all of us, 11, because we try to avoid a situation where 4 judges of the 8 could take one view and 4 take the other view, in which event you might not have a decision. So we try to sit all of us, and all these judges who were present at the court, if my recollection was correct, constituted a full court, and we consider these 4 cases together. It follows, in my view, therefore, that once one of the 11 is alleged to have been approached on a matter or is approached on the very issue that is before the judges or before the court, there may be a possibility of a contamination. My evidence, Mr. President and members of the tribunal, is that Judge Hlophe was attempting to influence the decision, taking into account all these factors that he was remarking about, to put together cumulatively. I then thought that he may be trying to influence the decision of the court. He did not influence me.
This is for this.
As I said, I snapped and immediately rebuffed him. And on this issue of privilege, we ended the matter there. When he said, "No, my sister, I do not mean to interfere with your work."
One final matter, and it's simply this. You had responsibility to produce that part of the judgment which dealt with privilege. Is that correct?
Yes, Counsel. Once you are allocated, in terms of the practices of the court, to prepare a post-hearing note, after you have circulated it, colleagues comment. And once the matter has then been deliberated upon following the comments, and justices are ad idem that we are unanimous, then the scribe allocated to write on the point will then draft kind of a judgment on that aspect. And this is precisely what happened here, because all other judges then brought together all their drafts, and then the pieces were then consolidated into a judgment. So my answer is yes, but then that process that has to happen, and then later the draft judgment will be prepared from the input of the person who has been allocated as a scribe.
But the simple proposition is this. By the time you met and spoke to JP, you had completed that part of the production that you were assigned, and it had been distributed.
Absolutely.
Thank you.
The post-hearing note, which is not a judgment, the post-hearing note was circulated already.
And that had been completed by you.
It was completed by me by 1 April 2008.
And you had completed it and only seeking suggestions from other judges prior to seeing the JP.
Indeed
Is that
so.
correct?
Indeed
Thank
so.
you.
It is the practice of the court that when you write a note, you circulate to your colleagues for comment. That was done.
And so as a result, you chose not to give him any access to that document you prepared.
There was no need for me to give him a post-hearing note. He's not a member of that court. There was absolutely no need to do that.
Precisely. And so it wasn't done.
It was not done.
Thank you very much. I have no further questions, Mr. Chairman.
Anything arising from these questions?
Thank you, Chairperson. Judge Nkabinde, whenever a note has been circulated and comments received from other judges or justices, are you allowed, or is it an opportune time for you to do the corrections and or additions?
Madam Evidence Leader, the practice of the functioning of the court is like this. You'll find this in what we call the working methods of the court, which is kind of equivalent to what judges and lawyers call a practice manual. That document spells out what happens when a case is to be heard and has been heard. Now, after a post-hearing has been circulated, judges are allowed a few days to comment on it, to ripen the deliberations at conference. After the comments, then judges sit at conference, all of them. We then debate on that note. If we are agreed, then they then give you a go-ahead to write a judgment.
So at that time when Judge President Hlophe came to visit you, were you still at a time when you could have changed if you were indeed influenced?
Indeed, because at that stage, the note had been circulated. Some colleagues had commented, others had not commented, and the matter was being prepared to facilitate deliberations for conference. It was to ripen that conference deliberations. But if I were to be influenced, which I was not and could not have been, in the circumstances, maybe let me put it this way, I was not influenced.
Now, for argument's sake, let us say, for argument's sake, you were influenced, which you were not. Were you in a position to could have changed that decision, or it was not possible?
If I were influenced, I had an opportunity to reconsider my stance. It happens all the time in the courts. Judges always change their mind. It happens often in that court where a dissenting judge will write even a judgment for that matter. And before even the delivery of the judgment, after rereading a main judgment, decides to jettison his or her dissenting view. So dissension or reconsideration of a view by a judge happens all the time.
Thank you very much. Thank you. That's all.
May Judge Ngabinda now be excused?
Chairperson, I just don't know if the team has anything to, out of what I asked.
Mr. Griffiths, yes. Thank you.
We have completed all the questions we wish to ask,
Thank
Mr.
you.
Chairman.
Ms. Tenga?
Thank you very much, Judge Nkabinde. You are excused, and thank you for assisting this forum. And you can go on and carry on with your normal work.
I thank you, Mr. President, and members of the tribunal. Thank you.
Chairperson, that is the conclusion of our case on the side of the evidence leading.
Yes. Mr. Marcus, has your situation changed at all?
Justice Labuschagne changed in the sense of...
Are you going to call any further witnesses?
No. And that is, of course, unless you direct otherwise, in which event I would want to address you on that first. But in the light of my learned friend's cross-examination of Justices Jaftarin and Kabinda, there is, in my respectful submission, no basis whatsoever for my clients to be called. If the panel is in agreement with that, my clients would be anxious to know that they too can get on with their other work.
Oh, yes, certainly. Well, I suppose the only other factor is a question of argument. And may we suggest argument on Thursday?
Well, sorry, Justice Labuschagne, I'm not sure what the Judge President's position is.
I'm sorry. Are you going to call further witnesses?
I am going to call the learned judge, President.
Yes. Do you want to start? Do you want to do it now?
No, we'd like to start now, please.
Yes, certainly.
Shall I just... Justice Labuskaghni, just while the Judge President's getting ready, may I inform my clients that their attendance is not required?
Yes, certainly.
Thank you very much.
And also, Mr. Chairman, can I mention that there are no additional witnesses to be called?
Yes.
Apart from the learned judge.
Yes, thank you very much. Judge President Hlophe, do you have any objection to taking the oath?
I have no objection whatsoever.
Do you swear that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth? Raise your right hand and say, "So help me God."
So help me God.
Thank you.
Thank you very much.
Now, Justice Hlophe, this is the second occasion upon which you have taken an oath before giving evidence. Is that correct?
That is correct, Mr. Griffiths.
Because on the 30th of July 2009, you gave evidence regarding the allegations being made against you, didn't you?
That is so. That is correct, sir.
And transcript of the evidence you gave, and I give this for the assistance of everyone, is to be found in volume 5 of the documentation available.
That's correct.
Commencing at page 83.
That's right. That is so.
And during the course of that evidence you gave, did you provide the court with all the recollections of the evidence?
Yes, I did to the best of my ability. Yes.
And were you cross-examined at that stage?
Certainly, I was cross-examined at that stage. That is so.
And can you recall by how many advocates you were cross-examined?
I do not recall the number of advocates present, but certainly there were a number of questions. I know for a fact Advocate Marcus was present at that inquiry, and also there were a number of questions that emanated from the members of the panel. The panel was chaired by the retired Mr. Judge President Bernard Ngwepe. Other members of the panel were Mr. Moerane, and the third one, I think it was an advocate, a senior counsel in Joburg by the name Ishmael Semenya. The record will speak for itself.
Now, that occasion on the 30th of July 2009,
yes, sir,
of course occurred after the witnesses we've heard from this week gave evidence in April of the same year.
That is so. I missed the hearing of April 2009. I was off sick at that time. We could not participate in that hearing.
So you were not present at all?
I was not present at all at that hearing. My lawyers applied for a postponement on the basis that I was off sick, and I had a medical certificate to that effect.
Let us now move to an introduction. What was your position when this complaint investigation began?
When this complaint came to light in May, I think 2008, I was the Judge President of the Western Cape, a position which I have been holding since the 1st of May, year 2000. So I was the Judge President and the sitting judge.
And assist us, please, with this. when had you first been appointed as a judge?
Mr. Griffiths, I was appointed as a judge on the 1st of January 1995. Prior to that, I've been serving as a judge in the Transkei Industrial Court for 4 years. Perhaps that explains why I never acted as a judge. I was appointed permanently as a Supreme Court judge on the 1st of January 2000. So I've been a judge from that time.
Well, assist me, please, with this, because I'm not a great mathematician. For how many years have you been a judge?
I've been a judge now, Supreme Court judge, for 26 years, and the head of the Western Cape High Court for a period of just in excess of 20 years.
And prior to that, you'd been involved in lectureship of law in universities, hadn't you?
Prior to that, Mr. Griffiths, that is so. I've been a lecturer, and ultimately I was appointed as a full professor and the head of department. In fact, Judge Jafta's evidence is correct in the sense that we first met in it was 1990 when I joined the law school at the University of Transkei. I was appointed professor and head of the department, and Judge Jafta was a senior lecturer in my department, specializing in constitutional law, and I think he also taught administrative law. Obviously, administrative law and constitutional law are my areas of interest. So we had a lot in common in respect of the areas of the law, constitutional law and administrative law.
Now,
perhaps I can add that he is also correct that we became friends. In fact, when he attended my wedding, at the time I got married, this is now prior to my divorce and my current marriage, he was present at the time when I married. So we were friends. He's correct in that sense.
next, do you confirm and stand by the evidence you gave in July 2009?
The evidence I gave Mr. Griffiths in July 2009, I stand by it, I confirm it, and I confirm the correctness thereof.
As a consequence, in light of the fact that this tribunal for this week have been considering the cross-examination of witnesses, I ask you no further questions regarding your evidence in chief, but now make you available for cross-examination by any party who seeks to do so.
Thank you, I'm available.
Thank you. Ms. Tenga, have you got any questions?
In fact, I'm not ready. I know I have questions, but I was taken by surprise. I thought...
Shall we go on
be
to
longer.
Mr. Marcus?
Thank you, Chair. I am happy to begin. Judge President,
Yes, Mr. Marcus.
you made a statement which was entitled Response to the Statement of Chief Justice Langa, filed on behalf of the Constitutional Court judges,
Yes.
and it is to be found in Volume 1 at page 88.
Sorry, I do not have that in front of me. Perhaps you can read it out to me.
It's your statement in response to the complaint.
Sure, I don't have it in front of me. Kindly read it out to me, the relevant sections there.
Could a copy please be made available to the Judge President?
Thank you very much. Just show me the relevant page of it. Page 88, sir.
It's
Thank
page
you.
88, and I'm talking about the volumes, Judge President, as opposed to what has been referred to as the books.
Page 88.
Page 88, yes.
Page 88.
It's headed Response to the Statement of Chief Justice Langa, filed on behalf of the Constitutional Court judges.
Sorry. Please bear with me.
Yes.
Page 88. Yes, you are referring top of the page. Yes, I'm with you, sir. That's right.
Now, and is it your signature which appears at the end of the document on page 158?
138.
158.
132, 138. $139. No. On page 138, there is no signature.
158, I beg your pardon.
158. Sorry,
158, yes.
158. I'll quickly go there. It looks like my signature. It looks like my signature. I know I am saying that I use two signatures at work.
I think we can take that as a yes.
Yeah, sure.
Judge President, although that statement was not made under oath, do you confirm that everything you say in that statement is indeed true today while you are under oath?
I have not gone through the statement. I haven't had the privilege of revising that.
Well, perhaps I could make it easier for you,
Sure.
Judge President. In subsequent proceedings, which were initiated by Freedom Under Law,
Yes.
you did in fact confirm the correctness of the facts set out in that statement. And if you want me to give you the reference, you will find that in the answering affidavit in volume 6, at page 277.
I believe you. If you say I did confirm that, I believe you.
Okay, so the sole purpose of my question, Judge President, is simply to get you to confirm that, as you did in the Freedom Under Law litigation, that what you say is contained in the statement you regard as the truth.
Yes, if I said so, undoubtedly I stand
Yes.
by what I said. I can't change that.
And I assume, Judge President, that that would obviously hold true for any other document that forms part of these proceedings which you have made or deposed to under oath. From time to time in the litigation, you've put up affidavits, and I assume that you stand by the correctness of what you said in those affidavits.
An affidavit is a statement made under oath. It must be the truth. I
Yes.
can't change it, therefore I stand by what I said before.
Judge President, in my learned friend's initial leading of you in chief, he asked you to confirm the correctness of the evidence that you gave in front of Judge President Ngwepe and my colleagues Murani and Semenya, which you did. Can I just correct one thing? It was suggested by my learned friend that you were subject to cross-examination during those proceedings, but in fact, the tribunal, under the Judge President Ngwepe, had made it clear that he was not allowing cross-examination at all. I can refer you to what he said in that regard in volume 5 at page 94.
Right.
I'll simply read it to you. He says, this is Justice Ngwepe speaking, and he says, Judge President, I think referring to you, I was just trying to consult with my colleagues on a procedural aspect. We are not going to have cross-examination. And the reason why we are not going to have cross-examination is because we wanted to point to only specific questions and therefore just restrict a witness to those particular questions questions as opposed to giving a full version of what happened from A to Z, which version is not going to be, if contested, is not going to be tested by cross-examination.
Right.
So while it is true that some members of the panel did indeed ask you questions, in fact, no cross-examination was allowed.
By lawyers?
Yes.
Fine, I accept that.
Good. Now, Judge President, before your meeting with Justice Nkabinda, which I think everybody confirms took place on the 25th of April, 2008,
Yes.
you had read the judgments in the High Court and the Supreme Court of Appeal in what we have referred to as the Zuma tint cases, correct?
I had browsed through the judgments like any other lawyer. Yes, I had.
Well, in your statement in response to the Chief Justice, which I hope you've still got in front of you, which you should find in Volume 1, at page 134, at paragraph 41.1, you said, "My knowledge of the Zuma case was based on judgments that had been handed down by the High Court and the Supreme Court of Appeal." Hence, I ask you the question, had you read the judgments before your meeting with Justice Nkabinda?
Yes, and I have admitted that.
Good. You were concerned that the majority of the Supreme Court of Appeal did not attach much weight to the issue of privilege, correct?
If you put it that way, yes. But the issue of privilege, Mr. Marcus, was an issue that occupied the minds and the souls of every other lawyer in this country.
Well, Judge President, when you say, if I put it like that, in fact, it is you who put it like that, because I was using the words which you used in your statement, which you'll find in Volume 1 at page 124, paragraph 29, in which you said you were, and I quote, "concerned that the majority of the Supreme Court of Appeal did not attach much weight to the issue of privilege."
Right?
So those were you accept those were your words?
If it's in a statement, it must be so.
It is indeed. And you had very strong views on the issue of privilege.
I had views on the issue of privilege, and in the sense that it's a long-standing principle of our law that information that has been obtained, privileged information between attorneys and clients, is privileged information. I was concerned. And let me remind you, that was also the evidence of Judge Jafta earlier on. He did testify that there were a number of colleagues, including colleagues in the SCA, who were concerned. That was his evidence today in response to questions by Mr. Griffiths. Yes, I was concerned.
Judge President, when I used the phrase very strong views, I was once again using the language that you had employed in your statement in response to the Chief Justice.
Fine.
You accept that?
Yes.
And you expressed those views to Justice Nkabinda.
When we met with Justice Nkabinda, when I went to her chambers, I did raise the issue of privilege, and I have given evidence in respect of the context in which that happened. Yes.
Could I ask you then, in your own words, Judge President, to tell the tribunal what those strong views were which you expressed to her?
Which I expressed to her, or to the views that were expressed by lawyers general?
No. We are only concerned in these proceedings with the conversations that transpired between you and Justice Nkabinda on the one hand,
Yes.
and Justice Jafta on the other, but I'm dealing with your conversation with Justice Nkabinda, and I'm asking you to tell the tribunal what those strong views were which you expressed to Justice Nkabinda?
I'm sure that is contained in my evidence, which I gave to the Commission in July 2009. But to my best of my ability, I did say to her the issue of privilege is important. There was a narrow majority judgment in the SCA, leading to confusion, and every lawyer was talking about it. So it was a broad statement of legal principles, jurisprudence.
You also told Justice Nkabinda that the Zuma matter had to be correctly decided.
That the Zuma matter?
Yes, had to be correctly decided.
In law, yes, to clear the confusion that was created, absolutely.
And in addition, you said that you even expressed views of your own on the legal issue of privilege to Justice Nkabinda.
I have my own views as a lawyer. I'm sure you have your own views as a lawyer.
Indeed, that is so, Judge President. I'm just confirming what you said in your statement, that you, and I quote, even expressed views of your own on the legal issue of privilege.
On the issue of general principles, yes. Not the facts, not how the decision must be made by the court. There is a big difference between talking about principles of law in general and talking about the facts of the case. There is a huge difference.
You held the view, however, which you expressed to Justice Nkabinda, that the SCA, the majority of the SCA, had got it wrong on the question of privilege.
I'm not sure whether I used those words, but even if I did, those were my own views.
Judge President, I'm not disputing that they were your own views. I'm simply getting you to confirm that those were the views you expressed to Justice Nkabinda on your own version.
If that is on the record, yes, I can't deny it. But those were my own views.
Yes. And you also expressed the view to Justice Nkabinda that the Constitutional Court had to decide the matter correctly.
Properly, yes, those were the words I used.
Yes. And so the very purpose of your conversation was to express the view that the Constitutional Court had to decide the matter correctly, because if you thought that the SCA or the majority in the SCA had got it right, there would have been nothing for the Constitutional Court to put right.
That was not the purpose of my visit, Mr. Marcus.
No, I didn't say it was the purpose of your visit, Judge President.
Yes.
I'm saying to you, I'm putting to you, that in expressing your view to Justice Nkabinda that the Constitutional Court had to decide the matter properly, that could only make sense in the context of the view which you had previously expressed that the SCA had got it wrong.
What I meant was that it had to clear up the confusion once and for all, which confusion prevailed in the legal fraternity.
Now, Judge President, you have told us and you've confirmed again this morning that you have known Justice Jafta as friends and colleagues, and I think your friendship probably now goes on to about 30 years.
Yes, I first met him in 1990.
Yes, that goes back to 1990. And your meeting with Justice Jafta in connection with the present matter took place in, we believe, towards the end of March 2008. Is that correct?
I think it was around 28th of March, if my memory serves me well, but it was in 2008. That's right.
And you remarked to Justice Jafta that the Constitutional Court was handling very important matters, in particular the Zuma tint matter.
Yes, I said it's handling very important matters. It is the law, it is the court. It's the apex court.
Indeed, but in particular, in the context of what you said to him, you mentioned the Zuma tint matter.
The context in which the Zuma tint matter must be explained. Let me be given an opportunity to explain it.
I'm not interrupting you, Judge President, please.
It is true that Judge Jafta, I spoke to him about the privilege matter, right, as a matter of principle. And he gave evidence earlier on and said that there were other lawyers who spoke about it, including other judges in the SCA. So it was in that context that I spoke to Judge Jafta about it. We did not discuss the facts of the Zuma stroke tint matter at all.
Well, you did say to Justice Jafta that you believed that the issue of privilege was a very concerning one.
It's a very important one, yes, and I've explained the context in which I said that.
And you also said to Justice Jafta that that concerning issue had to be dealt with properly.
Yes.
And the reason it had to be dealt with properly is that the Constitutional Court obviously was the only court in your view that could correct the error of the Supreme Court of Appeal.
And clear up the confusion and the law once and for all. That was my view and the context.
Can I just pause there, Judge President? You've mentioned confusion emanating from the Supreme Court of Appeal on a number of occasions in answer to my questions.
Yes, sir.
When you refer to confusion, by that do you mean that it was decided by the Supreme Court of Appeal by a narrow majority?
Well, the issue of privilege, communication between attorney and client, for decades, even when we studied law at universities, there was always privileged communication between attorney and client. There was a narrow majority of 3 against 2 in the Supreme Court of Appeal. It was an important question, so it was in that context that I raised it.
Judge President, I think you're agreeing with my proposition. The confusion to which you refer flowed from the fact that the Supreme Court of Appeal was not unanimous. In other words, within the Supreme Court itself, there were at least 2 dissenting views.
To some extent, yes, you're correct.
And as I understand the evidence that you've previously given, you accept having stated to Justice Jafta that Mr. Zuma was being persecuted just as you had been persecuted.
Let me give a context. May I?
Of course.
The context is as follows. When I arrived in the chambers of Judge Jafta, he was working on the Zuma tint matter. There were files all over. Jafta asked me, my brother, have your problems in the Western Cape come to an end? My answer was this: as long as I live in the Western Cape, nginyama nimbana. I will interpret that for you. Banyama nimbana, it means you are always someone who's going to be chased. People will always find problems with you. I use that Zulu expression, nginyama nimbana, and then I said, I'm just like Zuma. His problems will never go away. So I use it with respect in that context, and that is the evidence I gave way back in 2009. Yes, I use it in that context.
Still dealing with your conversation with Justice Jafta a moment, Judge President. You wanted, I think, to use your own words, you wanted the Constitutional Court to give the issue of privilege, and I quote you, satisfactory attention.
Once and for all, decide it either way. Either go along with the minority judgment or the majority judgment, as the case may be. But as the final court of the land, I was hoping that the issue will be resolved once and for all.
You also described Justice Jafta as an independent-minded and competent judge, as being very experienced and of undoubted legal skill and dexterity. You recall that?
Yes, that is so. Yes. I've known him for years. He's a solid lawyer, indeed.
And as I understand it, you said this to rebut the suggestion that you attempted to influence him as being an insult and is demeaning to the judge concerned.
Indeed, it is an insult. Judges take an oath of office to uphold the law, And no judge should be easily swayed by discussions or propositions or what we read in the newspapers. That's why we take an oath of office.
I raise that with you because on another occasion, also in your statement,
Sorry, which statement are you referring to?
your statement in response to the Chief Justice.
Right.
The one of the 30th of June, and I'll give you the reference if you want it. You'll find it at page 111 at paragraph 20, where you suggested that Justice Jafta was, and I quote, a relatively junior judge whose influence to the collective thinking at the court is likely to be marginal.
When he came at that time, that must be contextualized. He was acting at the time, and with due respect to him, I was not insulting him. He was not a permanent judge in the Constitutional Court. He was acting at the time. I even encouraged him to apply for a permanent position. So he was acting at that time. He was not a permanent member of the court. If one were to talk seniority, I think our learned sister, Justice Gabinde, in terms of seniority, was judge number 11.
Judge President,
been appointed.
I beg your pardon. Judge President, I don't suggest that you intended your reference to him as a relatively junior judge whose influence in the collective thinking of the court is likely to be marginal as an insult. I don't suggest that you were attempting to insult him there. I suggest something different.
Sure.
I suggest that on the one hand, I suggest that you blow hot and cold. On the one hand, you regard him as a very experienced, independent-minded and competent judge of undoubted legal skill and dexterity, to rebut the suggestion that he was even capable of being improperly influenced.
Right, that is so.
And on the other hand, you describe him as a relatively junior judge whose influence to the collective thinking at the court is likely to be marginal, to rebut the suggestion that if you had indeed wanted to attempt to influence the Constitutional Court, you would have chosen to try and influence a judge who was not relatively junior and whose influence on the collective thinking of the court was not likely to be marginal.
Mr. Marcos, with respect, the two versions are not irreconcilable. Justice Jafta is a seasoned lawyer. He was a seasoned judge even at that time. In the bigger scheme of things, however, he was going to be only one of 11 judges. There were so many judges in the Constitutional Court that I knew. Justice, I can name them. One of them was Justice Langa himself. I had known him for years. The other one was Justice Ngobo. I first met Justice Ngobo way back in the Legal Resources Center when we worked together in 1983. And we were friends. And on the day when I went to the Constitutional Court, I saw Justice Ngobo after my meeting with Justice Jafta, right? The other judge that I knew very well was Justice Madala, now late. He moved my application to be admitted as an advocate in Transkei way back, I think it was in 1990, 1991. So in the bigger scheme of things, Justice Jafta was relatively a relatively junior judge in that sense. He could not therefore be in a position, that was my point. He was not in a position to influence other judges because he was relatively, he had just been appointed, he was acting as a judge.
Now, Judge President, it is common cause that you did have conversations with Justices Jafta and Nkabinda concerning the Zuma Tint cases. I think that's accepted as common cause. The debate and the issue before the tribunal is whether those conversations constitute an attempt improperly to influence the court. We'll come to that in the moment. But you accept that your conduct would have been a breach of judicial ethics. And I'm going to use your words here, only if the matters before the Constitutional Court were appeals from a decision that you had made.
Sorry, I don't get the point, sir.
In your replying affidavit,
Yes.
in the High Court litigation which you initiated,
Yes.
I can give you the reference to it. You'll find it in volume 2. I wonder whether you have volume 2 before you.
No, I don't have it, but carry on.
Okay. In volume 2, at page 173, and perhaps in fairness to you, Judge President, I should read it from the original. You have a heading in your replying affidavit, and the heading is elementary principles of judicial ethics precluded.
Sorry, Mr. Marcus. Sorry. What page is that, sir?
It starts at page 172.
172.
Yes.
Right, I have the document in front of me.
Judge President, if you look to the bottom third of page 172, you will see a heading,
heading.
Elementary Principles of Judicial Ethics preclude a judge of one division from discussing the merits of a matter with judges of the highest court where judgment is still pending.
Right.
And you'll see you've given a footnote to that, and the footnote refers to Langa. That was what the late Chief Justice had suggested.
Right.
And here's your answer to that proposition from Chief Justice Langa. Your answer begins in paragraph 44, and there you say, I do not know what the Chief Justice seeks to convey by elementary principles of judicial ethics in the circumstances of the facts underlying the Constitutional Court's complaint
Yes.
on either the judge's version or mine. And then the paragraph that I want to put to you is in paragraph 45. There you say, his contention in this paragraph would have been correct only if the matters before the Constitutional Court were appeals from a decision that I had made.
Right.
So you now understand the context in which
Yes, I
you made that statement. What I want to ask you, Judge President, is, are you suggesting to this tribunal, well, let me go back a step. I take it you accept that had you been one of the judges at first instance,
Yes.
and your matter was the subject of the appeal to the Constitutional Court, that you accept that that would have been a fundamental breach of judicial ethics.
Yes, I do.
It's your use of the word only in the sentence that I've put to you in paragraph 45.
Yes.
And what I'm asking you is it your suggestion that it is only in the circumstances in which the Constitutional Court were sitting as a court of appeal on one of your judgments that the conversations with another judge would be regarded as a breach of judicial ethics?
Yes, the answer is yes. I'm fortified by this document. And this is Judicial Regulatory Instruments, page, I have it right here for you. I don't know whether you have seen it before. There is a section here, Code of Judicial Conduct adopted in terms of Section 12 of the JSC Act.
Yeah.
To be more specific, I'll take you to page 300. There's a section here, Article 11. It talks to restraint. Over the page, this is what Article 11.4 says. Article 11.3 says the following. Formal deliberations as well as private consultations and debates among judges are and must remain confidential. It doesn't say debates can only take place between members of that particular court. As lawyers and as judges, we talk about our cases every day.
Judge President, I don't want there to be any misunderstanding between us, and I think I need to try and clear this up. So let me go back a step. You accept the proposition that were the Constitutional Court sitting on appeal in relation to one of your judgments, it would have been a breach of judicial ethics to discuss the matter with any of the judges of the Constitutional Court.
Absolutely, I wouldn't talk.
But is it your position that outside of that situation, you regard yourself as free to discuss any pending matter with a Constitutional Court judge? Is that your position?
There is no law, Mr. Marcus, with respect, which says one may not discuss a matter with any judge.
Well, when you say there is nothing which says that, may I respectfully, Judge President, suggest to you the contrary, and suggest to you that as early as 1998, the Constitutional Court, relying on a decision of the Canadian Supreme Court, had indeed suggested the contrary. I have in mind the case of De Lange versus Smuts. I'll merely give the reference and I'll read the passage to you because it's not my purpose to have a legal debate with you, but I do need to put this to you. In De Lange versus Smuts, which was reported in 1998, volume 3 of the South African Law Reports, page 785, Constitutional Court, at paragraph 70, the Constitutional Court cited a decision of the Canadian Supreme Court in the case of the Queen in Right of Canada versus Beauregard, and this is the quotation from that case. It said, historically, the generally accepted core of the principle of judicial independence has been the complete liberty of individual judges to hear and decide the cases that come before them. No outsider, be it government, pressure group, individual, or even another judge, should interfere, in fact, or attempt to interfere with the way in which a judge conducts his or her case and makes his or her decisions. This core continues to be central to the principle of judicial independence.
Yes, but it doesn't say you can't talk about the law. Interference, in my view, is where you are trying to persuade on the facts. We are saying to the court, find this way or the other way. I fail to see where there is interference when you talk about jurisprudence, the general principles of the law.
Let me put the question slightly differently, if I may then, Judge President. I take it you have no difficulty in accepting the proposition that whether the apex court is sitting on a judgment, on appeal from one of your decisions, or in any other matter,
yes,
there are certain lines which cannot be crossed. So certain conversations, and that's what this tribunal is going to have to decide, is whether you crossed the line and whether, objectively speaking, your conversations with the two judges amounted to an improper attempt to influence Justices Jafta and Justices Nkabinda in a pending case. You accept that in an appropriate case, that would constitute gross misconduct.
Well, if there has been a discussion relating to the facts and there was an attempt, first of all, I had no idea what was the position of the respective judges. In my view, you cannot attempt to persuade someone to move from one position to the other if you don't even know the position where that particular judge stands.
Judge President, in relation to your visit to Justice Nkabinda,
Yes.
you said, if I understand your evidence correctly, that you were scheduled to come to Johannesburg for a meeting concerning the conference which you were organizing.
In respect of Justice Nkabinda,
Yes.
there were two reasons. Firstly, I had to report to Chief Justice Langa in relation to the mandate he had given me to chair the local organizing committee in Cape Town. This consisted of 4 judges. It was myself, Justice Willie Sireti, Justice Roelinga, and I think the 4th judicial officer was a magistrate. So I had to report to him in that regard. But there was another reason. On the 24th, There was a conference rather, a dinner, I beg your pardon. This dinner was hosted by the then Minister of Justice, Bridget Mabandla. I attended that dinner, and Justice Bess Ngabinde also attended that dinner on the 24th. She, in fact, gave a vote of thanks. I had been invited because I was instrumental in the training of aspirant women to become judges. Then a decision was taken in terms of which, as a person who convened that, I advised the minister that it would be better perhaps to reward them in order to fast-track them, reward them, because the idea at that time was to demystify judging, and there was a very limited pool of women. So my purpose of visiting Johannesburg was twofold. It was to attend that dinner, which was on the 24th, which Justice Ngabinde herself attended. I even met her husband at that dinner. But then the very next day, I had to go to Justice Langa and report on what he had asked me to do. Both Justice Ngabinde and Chief Justice Langa, now late, were present at the dinner which was on the 24th.
So, Judge President, that explains your presence in Johannesburg.
That's right.
Now, as I understand it, you had never previously made an appointment to meet with Justice Nkabinde. Is that
I
correct?
had made an appointment with respect.
No. I'm talking about prior to this occasion. I accept you phoned her on the 23rd of April. So let me rephrase the question. Prior to the 23rd of April 2008,
Yes, sir.
you had never made an appointment to meet Justice Nkabinde.
On the day when I met with Justice Jafta, Justice Jafta, after our meeting, escorted me to Judge Sandy Ngobo, right? When Ngobo accompanied me to the parking bay, that is when I saw Justice Ngabinde, who was in the company of the late Justice Tholi Madala. I said to Justice Ngabinde, my sister, since your elevation to the bench, I have not congratulated you. Next time when I'm in Johannesburg, I will pop in and see. That's contained in my evidence in chief, which I gave. So I had contacted her. Then when I was here on the 23rd, that's when I followed up something which I had initiated some 3 weeks prior to that when I was with Justice Jafta.
Judge President, I don't think we're disagreeing. Let me put it slightly differently. You had never previously visited Justice Nkabinde at the Constitutional Court.
I had never previously visited her. That is true.
And it is equally true that you hardly knew her at all.
I had met Justice Ngabinde, as I say in my evidence in chief, I think about 6 years or so prior to that. We met. We had common interests in labor law. But we're certainly not friends. We were colleagues. We had a cordial relationship.
I'm happy with that description of it. You phoned her on the 23rd of April, I think, as you've testified, and it was on that date that you arranged an appointment to see her in 2 days' time, correct?
Yes, because I was coming to Johannesburg. And then when I met with her at the dinner on the 24th, she introduced me to her husband. I said to her, I'm around, my sister. Can I pop in tomorrow? She said, yes, but my brother, I am doing duty. She was officially on duty with the late Chief Justice. Then she said to me, please make sure you come before lunch because I'm going to drive home and go home after lunch.
Did you know, Judge President, that you would be seeing Justice Nkabinde at the function on the 24th, or was that a coincidence?
No, I didn't know about that. It was a coincidence. I did not expect to see her at the function. I didn't know. But certainly I expected the Chief Justice to be there.
Thank you, Judge President. Just bear with me for a moment. Just to confirm a few further things, Judge President, you of course were not present during any of the various meetings of the Justices of the Constitutional Court that occurred in the period May and July 2008.
Yes, I was not present.
Yes. So again, obviously, and I think you accepted this in previous proceedings, you have no personal knowledge of what transpired at those meetings because you are obviously not present.
Yes, I have no personal knowledge.
Judge President, in the High Court application which you instituted, and I'll take you to the references if necessary.
Yes.
You accepted that the complaint against you was unanimous. In fact, you said as much on several occasions. Can I perhaps give you one example and just get you to confirm it? It's to be found in your founding affidavit in volume 2 at page 13 at paragraph 5. I'll simply read you the passage, and if you want to go to it, of course, feel free to do so, because I'm simply trying to establish a simple proposition. You said, and I quote, "The judges of the Constitutional Court, acting as a court, took the unanimous decision, or as a court unanimously decided, to support the decision of the Chief Justice or Deputy Chief Justice to lodge against me a complaint of gross misconduct on the basis of ex parte representations made to them by two judges of the Constitutional Court." The only proposition I'm putting to you, and there are three other passages I could refer you to if you want me to, is that you accept that the decision to lodge the complaint against you was unanimous.
Well, according to the Constitutional Court documents file, that was so I cannot argue against that.
Okay. And Judge President, in the freedom under law litigation, the SCA recorded at paragraph 52 the following, and again, if necessary, I can take you to the judgment, but I don't think it's going to be controversial.
Yes.
They record the following at paragraph 52. They say, "Hlophe JP made it clear at the interview that he had no complaint insofar as the Constitutional Court judges were exercising their right to report him to the JSC. He conceded further that he had to accept the version of the Constitutional Court judges that their conduct was inspired by their desire to protect the institutional integrity of the court." And I assume that you accept that proposition.
If I accepted it then, with respect, I have to accept it now.
Good. Again, bear with me, Judge President, that these consultations with my junior are designed to cut the cross-examination shorter. You'll be pleased to know, Judge President, that my junior has saved a fair amount of further cross-examination. Can I just take you through to some further matters, and I think I can be relatively brief about this.
Yes.
At the time of your conversations with Justices Jafta and Justices and Justice Nkabinda, you knew that judgment in the Zuma Tint matters had not been handed down yet.
It had not been handed down yet, yes.
And again, I think this is common cause. You also knew that both Justices Jafta and Nkabinda were sitting on those matters.
They told me so, yes, I knew.
Thank you, Judge President. I've got no further questions.
Thank you.
Yes, just a few questions. Thank you, Mr. President. Good afternoon, Judge President.
Good afternoon, Ms. Norman.
I just want to understand, at what point did you become aware that if you were not a judge of the Constitutional Court or sitting as a judge at the Constitutional Court, you were not permitted to discuss cases with judges of that court? At what point, for the very first time?
The very first time it was when, if my memory serves me well, when Judge Jafta filed his reply. That's when I became aware of it for the first time, because he referred to the practice in the Labour Appeal Court as well as the Supreme Court of Appeal, and he added that he doesn't know whether I knew about that rule because I never sat in those courts.
Yes.
Right? That was the first time.
Yes, thank you. He also, as you correctly point out, he mentions the Labour Appeal Court. Did you at any stage serve on that court?
I served on the Labour Appeal Court for more than 15 years on an ad hoc basis until fairly recently, yes.
And at that court, was this rule that if you didn't sit on any appeal, you were not permitted to go and discuss?
To the best of my knowledge, there is no such rule. I have sat with so many judges, including so many judges, there was no such rule.
Yes.
To the best of my knowledge, there is no such rule. And I must add, Judge Jafta gave evidence here earlier on. He said there were so many people in the profession, including SCA judges, who were talking about this. That was his evidence earlier in response to questions by Mr. Griffiths. So I'm not the only one who spoke about it. Even SCA judges were talking about it.
Yes. Other than the judges sitting in different courts, you've got judges in the High Court, Supreme Court of Appeal, and the Constitutional Court. Are there any rules that define the conduct of the judges from the various spheres of the judiciary?
The only rules that I'm aware of are the rules of ethics plus the rules contained in this book, yes, which regulates the conduct of the judges and discipline. And I read an extract earlier on in this book, from this book.
And given what Section 165 of the Constitution says, when it deals with judicial authority,
that's right.
165(3) reads, the judicial authority of the Republic is vested in the courts, and then 3 reads, no person or organ of state may interfere with the functioning of the courts. What is your understanding of that section?
It would be wrong for a member of the public or a judge or an institution to interfere with the proper functioning of the court. It can happen administratively, it can happen in a number of ways. Or, simple example, if a judge goes to the court and say, acquit so-and-so, who's appearing in criminal trials, for instance, because he's my neighbor or because of this, there you are interfering, you want particular results on the facts. But if you are talking about jurisprudence, judges talk about law every day. And I remind you again, Judge Jafta gave evidence earlier on here and said there were so many judges, including SCA judges, who spoke to him about the issue of professional privilege. None of them is being prosecuted.
Yes. Before this, that is the meeting that you had with Judge Jafta in March of 2008, were you aware of how the Constitutional Court works insofar as its hearing of the matters? Were you aware of its practice directives?
No, I was not aware, Ms. Norman, and quite frankly, I fail to see how one can try to influence anyone if I don't even know what your position is on any aspect, let alone trying to persuade you. I can only persuade someone if I know what that person's position is.
Just a minute, sorry. All right, sorry, this is just a note from Justice Ngabinde, sorry, that she said I must put it to you that she never told you that she was sitting as a member of the bench that had the Zuma matters.
She told me she was writing something.
Yes.
She told me when I went to her chambers, when we had tea, that she was writing something. The judges were going to sit together. She told me.
Now, supposing that this matter, or maybe let me put it this way, was this the, if you say that you knew Justice Langa, the Chief Justice Langa, and you knew the former Chief Justice Ngobo, had you had any discussions with them on any other principle of the law, as you did with Justice Ngabinde and Justice Jafta?
We did not speak about anything on that day. I'm talking about Justices Langa and Ngabinde on the question of privilege. We did not talk about that. I spent a great deal of time in the chambers of Justice Ngobo, whom I had known for over a long time. There is no suggestion whatsoever that I discuss with him the Zuma tint matter or anything. I also saw the late Chief Justice Langa on that day. It was a scheduled meeting immediately after my meeting with Justice Ngabinde, and I told Justice Ngabinde I am on my way to the Chief Justice. There is no suggestion whatsoever that I discussed any law or any facts of the case relating to the Zuma tint matter. There were other judges, as I have said, that I knew well, including Madala and the late Square. There is no suggestion with respect whatsoever that I engaged them in any way. It was in that context that I said Judge Jafta was relatively junior in the, in the Constitutional Court. It was not to undermine his intelligence or his ability as a lawyer, but it was in the broader scheme of things that there were so many other judges that I knew that if I was intent on attempting to influence them to decide one way or the other, there were so many other judges that I could have approached.
Yes. Would you agree with me that overall, most of the areas that had been identified by the Supreme Court of Appeal in this judgment as areas of where there's disputes of facts between your evidence and that of Justices Ngabinde on the one hand and Justice Jafta on the other, given today's hearing and the evidence today, those have been narrowed to a very large extent?
Yes, I agree. That's why I agreed. I've availed myself to be cross-examined on any aspect arising out of this case.
Thank you. Thank you. Thank you, Mr. Chair.
Ms. Tenga.
Thank you, Chair. Judge President Hlophe.
Hello, Ms. Tenga.
Yes, afternoon, and how are you doing?
I'm fine, thank you.
Thank you so much. You said you saw Judge Ngabinde the previous day at a function.
On the 24th, yes.
Yes.
In the evening, that's right.
And at that meeting, you also saw some other judges that were present?
Chief Justice Langa was definitely present there. Justice Nkabinde was present. She was called upon to give a vote of thanks. There were quite a few other judges present. Mr. Bezos was there. He's not a judge, of course, but there were so many members of the legal fraternity because it became a big event. We're honoring women who have been fast-tracked because the idea was to demystify judging, so we're honoring that. There were so many other judges who were present.
Thank you for that explanation, Judge. Why did you need a special meeting to congratulate her in her chambers than to say, congratulations, my sister, at that function where she was, where you saw her?
It was to follow up on the promise which I made earlier. Remember, my evidence was this earlier. On the day in March when I visited Justice Jafta, when Justice Sandile Ngcobo escorted me from his chambers to the car, I came across Justice Nkabinde, who was accompanied by the late Justice Toli Madala. We greeted each other. I had not congratulated her since the appointment. I said, my sister, next time I'm in this court or when I'm in Joburg, I will pop in your chambers and congratulate you. So it was a follow-up on that. I must add, on that day, when I went to the parking, as I was accompanied by Justice Sandile Ngcobo, I came across a bodyguard who had protected me before. I asked him, who are you protecting now? After he greeted me, he said, I'm protecting Deputy Chief Justice Dikgang Mosinek. At that time, I had his cell phone number. I called him. He didn't answer the phone, but there is no suggestion. There I left a message for him and said, I'm coming back to talk to you on the issue of privilege. There was no such. So the simple answer, it was a follow-up on a meeting that I had promised her when I saw her previously when I met with Justice Jafta.
Yes, I understand, Judge President. A call away from where you are to the judge, Judge Nkabinde, was it not going to be enough to congratulate her than to personally go there?
Can I answer it this way? I was in the Constitutional Court before. She saw me in the Constitutional Court. There were so many other judges that I knew in the Constitutional Court, including Justice Nkabinde. She's not a stranger to me. We may not have been so close, but the bottom line, as a fellow black judge and a woman for that matter, I felt I had to congratulate her on her elevation to the court. In my view, there is nothing wrong with that. Unless if you tell me I'm a persona non grata in the Constitutional Court.
No, that is not what I'm trying to say. Judge Hlophe, you heard the evidence of Judge Jafta.
Yes.
That after Judge Nkabinde confirmed that you called her asking for a meeting.
Yes, ma'am.
She was informed, I will not use the word warned, she was informed that by Judge Jafta that she take care of the situation that you might discuss a case of Mr. Zuma at that time when you will be visiting. Did you hear that?
Yes, I had the evidence of Justice Jafta in that regard.
Now, do you want to tell this forum that it is just a coincidence that you choose not to call her, you choose to go there to Judge Nkabinde personally, and also it is a coincidence that Judge Jafta warns or informs Judge Nkabinde of the possibility, and that possibility end up happening? Do you want to tell this forum is a coincidence?
I cannot, with respect, comment on the discussions between Justices Jafta and Nkabinde. I was not privy to that. But it was not coincidence that I went to the Constitutional Court. I had said earlier on to Justice Nkabinde that next time I'm in this court, I will pop in, my sister, and visit you. So it was not a coincidence, it was pre-arranged, but it was a question of a specific date that was not fixed.
From where I'm sitting, it looks like you were struggling or you were on a mission. I have no words to explain, but there was something pushing you at that time to make sure that you have contacts with these judges of the Constitutional Court, just before the judgment could be issued out or could be delivered, so that you put across whatever you wanted to put, which was banning you?
The answer is definitely no. There were so many other judges of the Constitutional Court that I met in that period of time. I have mentioned Justice Langa. I had mentioned Justices Dihang Mosineke on the phone. I had mentioned Justice Skweyiya. I had mentioned Ngobo, and I think the other judge that I met at that time, Skweyiya, Ngobo, Pius Langa, Madala. Those are judges that I met during that time frame, in addition to Justices Ngabinde and Jafta. And there is no suggestion that I try to do anything to those judges.
I just want to put it to you, Judge President, that the banning issue at that time was to discuss that which you went to discuss with the two justices.
No, I dispute that. Had that been the case, I would have discussed that with other judges as well.
You had Judge Jafta this morning explaining that it was not acceptable for a judge to discuss with another judge a pending matter where he's not involved in, this other judge.
Justice Jafta alluded to that evidence, but prior to that, in response to being questioned by my counsel, Queen's Counsel, Griffiths, he said at that time there were many members of the profession, including SCA judges, who spoke to him about this. I recorded his evidence. If necessary, we can play the tape.
No, let's leave that aside. I just want to know, in your professional life as Judge President in the Western Cape, have you ever met or come across such a decision or such a situation where you needed to take action because there was a discussion, be it of a view or an opinion of some sort regarding a case?
Personally, I've never had to take action, but your point was it related to discussion. I'm saying the evidence of Judge Jafta is very clear. In response to being questioned by Mr. Griffiths, he says there were judges of the SCA as well who were equally concerned about this.
Sorry, Judge President, I did not get your answer properly. I don't want to misunderstand you. Did you say you personally did not have to take action against such incidents where somebody discusses an opinion or view regarding a pending case?
No, I've never come across a situation whereby I had to report a judge to the Judicial Service Commission for that. But judges talk about work every day.
And what about an assessor?
We don't use assessors now, certainly not in the Western Cape.
All right. You recall the case of State versus Mayekiso? The State versus
I wrote that judgment, yes.
So is it not relating to the same issue we are talking about?
Far from it. I authored that judgment. Read the judgment, please.
Remember what I said was, when you discuss, you are involved in the matter, you discuss the issues, and you said to this forum, you have never got involved in such a situation.
Where I had to...
Not in the Western Cape, you don't even use assessors. That's what you said.
Please. At the time of that judgment in the Mayekiso matter, we used assessors at that time. There's no question about that. I wrote that judgment. I know the facts in that matter. But we do not use assessors now. So my answer was simply this. I've never, in my capacity, no doubt, as a JP, come across a case where I had to report a judge to the JSC.
But it boils down to somebody wanting to talk about the views he or she has about a case which is pending. Are we agreed?
Talking about jurisprudence, we do it all the time. There is a clear distinction between discussing law. It enriches you. I challenge you, tell me a single judge who does not talk about his work with other judges. I challenge you, we do it all the time.
Now, in this instance, why did you have to order that the case starts de novo?
Please, you're asking me, are you suggesting that the case was wrong?
No.
I ordered the judgment. I thought this was an inquiry about whether or not I committed any gross misconduct. It's a totally different case, and with respect, it bears no relation to this.
Perhaps let me ask you, Mr. Judge President.
If you think the judgment was wrong, be it, so be it.
No, that's not what I'm going to. I just want to know, do you remember the facts, maybe so that I can assist you if you have forgotten them?
Ma'am, I remember the facts. It was my judgment. I sat with this particular assessor, and when the court adjourned, I went into my chambers after tea. He was busy with my secretary, and I think there was counsel as well, talking about the very case, and he said, in his view, this matter has come to an end. This particular person, Mayegiso, must be acquitted. Right? There is a clear distinction between talking about the law, it is jurisprudence, and talking about the facts of the case and expressing your views about a particular outcome. I know the judgment, I wrote the judgment.
I agree with what you are saying, Judge President, but I want to refer you to your statement that you responded, which made me to draw this judgment, just to remind you. You said talking of principles and view are two different matters in this forum today. That's what you said, Judge President.
That's right.
And that is why I'm asking, why did you have to take action to or against that assessor, and you ordered that the case start de novo for expressing his view, when you are saying today it doesn't matter if you express your view in this forum?
Please allow me to repeat myself.
Okay.
There is a clear distinction between talking about jurisprudence, expressing your views about the general principles of the law, and saying, apply this law to these facts, and based on these facts, the accused must be acquitted. What do you do when you sit with an assessor? In those days, we used two assessors. One of them already expresses the view that the accused must be acquitted, and that view is communicated to counsel and the secretary. What do you do?
You see, Judge President, your situation is even more severe, if I were to use that word, because you are coming from another jurisdiction to the apex court, wanting to talk about cases that you are far from.
Hence, I had no interest in the matter. I could never have spoken about a case, for instance, arising out of my own. I could never. But a case in which I have absolutely no interest is a mere expression of my view. Remember, I was an academic. I have a keen interest on law and jurisprudence.
And I just want to remind you, Judge President, that Judge Jafta mentioned this morning that it is not acceptable to discuss. And I suppose whether you are discussing a view, a principle, as long as you are not seized with that matter, and that matter is still pending also.
That was his evidence, but with respect, Justice Jafta, in answer to being questioned by Mr. Griffiths, he said, I quote, there were many colleagues in the profession, including judges of the SCA, who expressed views about the matter. Ironically, they are not being charged.
Right. In conclusion on this matter, whether you can discuss any view or principle with any other judge and or assessor, I want to refer this forum to this case so that you can refer or read so you satisfy yourself if I'm on the right track. The citation is State versus Mayegiso and others, 1996, volume 1, SACR, page 510. It's a Cape decision.
I'm not afraid it was my judgment. There was no appeal against it. I'm not
No,
afraid.
we are not saying that, Judge. I just want to give them the opportunity to read the issue of the view and the principle. That is what I'm getting at. Right, Judge President, there was an issue around the expert that was sent through to assist this forum in
Yes.
order to arrive at a fair decision regarding the phrase.
Sestembelegnina.
Correct. Now, if you look at page, it's volume 3, page 265
Yes.
until 266, where Seligson said, what did you understand the Judge President to be implying when he used this expression, Sesi Tembele Kinina? Excuse me. And then Judge Jafta said, well, I thought he implied that we would correct what he considered to be the wrong by the SCA. I will not read the other one which he corrected. By the SCA, I'm sorry, the SCA has got it wrong, and I thought then that's what he wanted to give a judgment that will correct what has been said by the SCA. The point I'm driving at is the expert yesterday informed this forum that at that time when you were talking to or with Judge Jafta, your understanding of that phrase was the same.
That was the evidence of the expert?
Yes.
Until the 28th of May 2009. That evidence is very, very clear. He said there was a common understanding that that statement, says Tembelegini, relates to integrity, the process, but not the outcome. Things changed after the meeting of the 28th of May 2009, the minutes of which are not available. That was the evidence.
Let me, Judge President, for a moment agree to what you are telling this forum. Then I ask you, Judge President, why did you think Judge Jafta saw it necessary to warn Judge Nkabinde that you were coming? Just before that meeting, if there was nothing untoward.
Well, I do not know. I was not privy to that discussion. I do not know. It would be wrong for me to speculate. But assuming that indeed he warned her, her conduct subsequent to being warned is not consistent with someone who has just been warned that a naughty person is on his way to your chambers.
So now, why do you want this forum to allow you to speculate on the outcomes of the meeting, which you don't have the minutes of?
I'm not speculating as to the outcome of the meeting. I'm referring to the evidence of the expert, which was led here yesterday. He said, and I repeat, there was a common understanding between us that we have faith in the process, in the constitutional court as the court as an apex court. There was common understanding that I was not trying to say find in favor of Zuma. And I think that's the reason why there was correction of the text earlier on. Things changed after the meeting of the 28th of May 2009. After that meeting, another version, they started, the other version, i.e., you are our last hope, which is clearly wrong. It is a loose interpretation. It is clearly wrong. I do not understand why, when there are at least 5 possible correct interpretations of the phrase, why a wrong interpretation was chosen.
In conclusion, Judge President, I just want to say to you, you want to speculate and give this forum your speculation where it suits you, and when it doesn't, you refrain and you want to step back and say, I can't speculate.
Ma'am, with respect, I do not agree with that proposition. I've answered your questions honestly. I was not privy to the meeting of the 28th, but it is a fact that after the 28th of May, a different meaning, which is totally wrong, was assigned to the expression "sestembelekile." It is a fact. That is the evidence of the professor. And there is nothing to gainsay that.
Judge President, just to assist you, I am making a submission that you only want to speculate when it suits you. And the reason why I'm placing that submission on the table of this forum is because I'm asking, why was it necessary for Judge Jafta to correctly guess, if I were to use that word, guess that you will speak about the Zuma matter when you meet Judge Nkabinde? Why was it why did it happen exactly like that?
My answer is I don't know and I cannot speculate. But as to the meaning assigned to the phrase "sestembelekile," I'm not speculating with respect. That was the evidence of the expert, and it has not been gainsaid. It's there.
No, Judge President, I just want to know, in other words, why such a coincidence that Judge Jafta sensitizes Judge Nkabinde? Be aware this might happen. And it happened. Why such a coincidence?
I've already answered you, really.
I didn't get the answer, sir.
Ma'am, I have said I cannot speculate. I was not there. I do not know what informed. I was not privy to the discussion between the two judges.
But in the same breath, you want this forum to allow you to speculate on the discussions that took place and the after actions of that meeting, which you were never favored with the minutes.
Ma'am, with respect, I'm referring to the evidence that was led before this forum yesterday. We are all present here. We all had the evidence of the professor. By the way, it has not been gainsaid. The professor made it clear that there was a common understanding between Jafta and I with regard to the meaning of the Zulu expressions as "sestembelekile." That much is clear up until the day of the 28th of May 2009. I'm not speculating. That is the evidence that was led before this court. I was present.
Let's now come to Judge Nkabinde's chambers when you were there. You heard her evidence. She testified to this forum that you mentioned that there are certain people that might lose their job when Mr. Zuma becomes president.
Not judges.
No, I'm just referring to the discussion. What you discussed when you arrived in her chambers?
You put it to me that I said there were certain people that could lose their jobs and there could be a cabinet reshuffle. It happens everywhere in the world. But I didn't say judges will lose their jobs. Judges are permanent.
But Judge President, did you utter those words in the chambers of Judge Nkabinde?
We were talking in part politics. I talk politics. I'm a political animal. I do talk politics. There is nothing wrong with that. Anyone who's I'm not politically naive. We're talking about events in the country. I did mention that. There is nothing wrong with that. I did not say judges will lose their jobs. Judges have tenure.
Did you also mention that the word or the privilege the issue of privilege was never dealt with properly in the SCA.
We did talk about privilege, yes. Just like I raised that with Judge After, yes.
And when she rebuffed you, did you see that or you didn't take notice of?
Well, I dispute that. I've already said in my evidence, she did not rebuff me. She did not.
What happened?
We spoke about privilege. I did not get into the facts. And as we were speaking about it, the telephone rang because Justice Langa was expecting me to be in that court. So when she phoned me, I left. She never rebuffed me. We were having coffee, tea or coffee in her chambers. There was no question of being rebuffed by her.
And what else did you speak when you were there in her chambers?
It's all contained in my evidence in chief.
Okay. And also, did you speak about him being persecuted like you are
Yes,
persecuted?
I did. I even used the Zulu expression, unyama nimbana. Yes, I did.
Okay.
That was
So,
even...
in short, you are confirming that which is contained in the affidavit, especially on Volume 1 and Volume 3, that which you responded via an affidavit.
I confirm the contents of my affidavit, yes.
Thank you very much. Thank you.
Mr. Griffiths, have you got anything to add at this stage?
Not at all in relation to the presence and continuation of this witness. None whatsoever.
Thank you. I take it Judge President Hlophe may be excused at this stage. Thank you, Judge President. You are excused.
Excused as a witness, thank you.
I do not know if we all are ready to argue, or should we submit something in writing, or what do we do?
Written arguments will be appreciated, certainly, and for that purpose, shall we adjourn until Thursday and do the argument on Thursday, which will give counsel a chance to prepare written heads of argument.
Certainly from our perspective, that would be very welcome. I would simply merely add that I'm fairly confident, having spoken to Mr. Chilowani, that we will not have a typed transcript. So with that reservation, obviously we've been taking careful notes of the evidence, but we will certainly present argument on Thursday.
Thank you, Mr. Marcus.
Can I say in that regard that we hope that the transcript of yesterday and today's evidence, so which is quite a short period, could be available as soon as possible?
Well, Thursday, to agree. We're going to listen to the argument on Thursday. Yes. Are you prepared to submit, arguments on the notes that have been taken, surely by your people?
Well, of course, sitting here, I have no idea what the extent of the notes are, or even its accuracy.
Well, what are you suggesting?
What I'm suggesting is that we could do this argument on Friday, because there's no further evidence.
Yes.
No further concerns about the timetable. And I'm also anxious that we concluded this week And I believe that if there's a transcript available which prevents any misconception between the various council involved,
Yes.
that would be helpful to everybody, including you judges.
Mr. Marcus, Friday,
I have no objection to Friday, but based on my discussions with Mr. Chilowani, I'm very doubtful we'll have any transcript by Friday, but he is the person to confirm that. So if the situation is that we are not going to get a transcript by Friday, then I would suggest Thursday should proceed, but I think he should tell us.
Well, I believe that there is a possibility of the transcript to be ready on Thursday. So we stand adjourned till Friday, 10 o'clock, Friday morning.
I'm grateful.